left.
Mm-hmm. Yeah.
I think this last week of term, many people are self-isolating, many have tested positive, many have left, especially our international students have gone back to their countries. So this past week has been a little bit of a problem, but I think we need to wait and see until February what will happen and after the holidays.
Yeah. So how many weeks for the holidays in UK?
It is 2 weeks of holidays. So we start back on the 3rd of January. And then the rest until the 25th is exam period. And next semester starts on the 25th of January.
Okay, I see.
So I think we need to wait and see what will happen in the next few weeks, although things don't look very good at the moment.
How about the vaccination? Staff members and the students normally have taken the vaccination, or? Yeah.
It's not obligatory, but I think most staff members, if not all, have been vaccinated. Now they are offering the booster dose. So everybody is now able to get the 3rd dose. And for students, everybody is eligible. What we did at Queen Mary, we have also a vaccination center inside the campus. So all new students, especially international students who weren't able to be vaccinated in their home countries, could be vaccinated in the past 3 months.
Okay.
And I think now to get the 2 shots, and now they say that the 3rd shot is possible 4 months after your 2nd shot.
4 months, okay.
For the 3rd dose.
I see.
Are they doing a booster shot in China as well? A 3rd shot?
Yeah. Normally, we are taking the 3rd shot after 6 months after the 2nd. So I'm still waiting some days to get the 3rd because I took the 2nd a little bit later in July, I think, or August, I'm not sure. So I should wait until February next year.
I think for me, I had my 2nd shot in July, so I would have to wait until January. But now, because of the Omicron variant, they let everybody take the 3rd shot even earlier. So as of 4 months. So I have booked mine for this week.
Okay.
I'm having next week my 3rd shot, a little bit before the 6 months.
So let's take care all together.
Exactly.
Okay. So let's start. It's already
as you like. If you want to wait a
5
few more
p.m.
moments,
in Beijing time. So let's start. So good morning or good afternoon, dear friends, online friends, and welcome to our conference EU lecture. I will firstly introduce what is EUPLANT lecture and then give a very brief introduction of Dr. Angelos Dimopoulos. Sorry. And the Jean Monnet Network EU China Legal and Judicial Cooperation means EUPLANT. This project investigates the interaction between the Chinese and the European Union legal and the judicial systems and promotes excellence in teaching and research on EU-China legal and judicial cooperation. Through a set of research, policy, and outreach activities, EUPLANT creates new avenues for enhanced academic and policy cooperation between the EU and China, and engenders a better understanding of each other's legal system. At the same time, EUPLANT is generously supported by the Lifelong Learning Program. Dr. Angelos Dimopoulos is a senior lecturer in law. Prior to joining the Department of Law, he was assistant professor at Tilburg University and the research coordinator of the Tilburg Law and Economic Center. Dr. Dimopoulos obtained a PhD in law at the European University Institute in 2010. He holds degrees from the Universities of Cambridge for his LM Hanover for MLE, and Thessaloniki for LLB. And he has qualified and practiced as an attorney at law in Greece. So I hope all the informations are correct. If there is some mistake, please correct me. So thank you so much to Dr. Angelos Dimopoulos for accepting our invitation to deliver this lecture. And I will give the floor to Dr. Angelos, and after your lecture, I will open the floor for some discussion. Any question from the audience could put up to Dr. Angelos, and I expect a fruitful discussion after the lecture. Thank you, and please go ahead, Doctor.
Thank you very much, Ben, for the very kind introduction, and thank you for the invitation to speak to you today and to contribute to the work that EUPLANT is doing on understanding better EU-China relations and interactions between the EU and the Chinese legal system. And I hope that what I will be discussing today would be an opportunity to address this interaction on a level that has created a lot of discussion in the media, in Europe in particular, and to my knowledge in China as well. So the topic that I want to focus on today is the area of investment screening. I think to give the media background to the topic that I want to discuss, you may have heard of a number of investments, in particular in telecom and in 5G, and contracts being given to 5G in different countries, particularly in the US, but also in the UK and in other countries in Europe. And the discussions about whether one should allow a foreign investor coming from China make such an investment in such a critical industry. What I want to discuss is the EU legal framework concerning authorization of foreign investments. I have prepared some slides, so I think while I'm speaking, I will have my slides in the background so that you could follow my train of thought. If there is any, let me start by saying that if you have any questions, you can always put them in the chat, and we can, because you may have some questions while I'm speaking, you can raise your hand afterwards, I think, when we'll have the discussion, as been mentioned. But if you have any questions, put them in the chat. Maybe I can explain something a little bit further. Maybe I could go back to a topic if you want me to. So I think that's always a good idea to interact. So bear with me one moment until I find my my slides. Okay, I think now you can see my slides in the background. So what I want us to discuss today would be three key issues to understand the world of what we call investment screening: the authorization that foreign investors are required to obtain when they need an authorization to invest in a country. The first point that I want to discuss would be what we mean by investment screening and why it has become very important, and why more and more countries are developing an investment screening mechanism. Then I want to discuss the EU framework on investment screening, and this is particularly important because the EU has taken action very recently in this area. There is a regulation adopted in 2019, and this regulation has entered into force only last year. And a few weeks ago, the European Commission issued its first report on how the regulation has been working in its first year. It's interesting to see also that this regulation what I want us to discuss would be what it covers, why it covers what it covers, and what are the pros and the cons of this system from the perspective of different actors. A key point that I will make when we discuss the EU legal framework is that this is an umbrella framework that allows EU member states to have their own systems for investment screening. From all the 27 member states, I think for reasons of language and for reasons of looking into one of the most important member states, I will discuss a little bit how the French model, and I think France is a key example because it presents one of the most complete systems on investment screening, one of the most recent and updated ones, and I think economically speaking, one of the most important markets within the European Union. Let's have a look into these three questions, and let's start by investment screening. What do we mean by investment screening? This is nothing else than the practice of authorizing inward investments. So to the extent in investment law, most of the debate, especially if we're thinking about international investment law, has to deal with protection of foreign investment or admission and liberalization of foreign investment. What we'll be discussing today is about the domestic legal framework, which basically are about the conditions for authorizing inward investment or not. Authorization of inward investments is nothing new. It has been there for many years. It has been, I would rather say, the rule in many countries in the past. And this is because it is part of the rules on investment admission. And I want to spend some time in a few minutes to discuss how the rules on investment admission have evolved in the past 30 years, where from a system where every investment was subject to authorization, now have moved to a more open system. Now investments are freer. There is a system of liberalization. So we need to consider what this has resulted in was to reconsider when we need an authorization, when foreign investors, if there is more openness and more liberalization, we need to reconsider when do we need authorization, and which are the instances where states should be able to screen potential investors and give their green light if they want that investment in. The key rationale why we still need authorization if we have more openness and more liberalization is the need to protect from security risks that foreign direct investment poses. And this introduces this is important because when we talk about investment screening, an approach today is that the only valid grounds to refuse an investor, to refuse a foreign investment, is only when they pose a security risk. So non-security risks, these are economic, competition related. These shouldn't, if they are not, they should not qualify as a ground for denying authorization. And this is a way of trying to balance openness and security. Investment liberalization where foreign investment is welcome, but also the need to deny authorization and the need to pre-screen investments if one needs to protect certain security interests. However, if we need to think of this balance, this raises a number of other questions that I want us to discuss through the eye of the EU. These questions are, so which investments pose a risk? Is it all investments or some types of investments that can actually pose such a risk? More importantly, what is a security risk? So there are different, security is a concept that is in most jurisdictions and legal systems very broad. And there is a debate in the context of investment screening as to what do we mean by protecting national security? And we will go into that discussion as well. A third similar question is, who are the investors? So not only what are the investments that can pose such a security risk, but are these risks posed by what type of investors? What is the context in terms of those foreign investors who may pose this type of security risks? And when you're talking about investments, we need to consider, do these risks arise in all economic sectors that are open for foreign investment activity, or only in some of them? And if it is only in some sectors, then in which ones? The last point that I want us to go through is to think that these questions have evolved and have changed a lot the way we think about them today from the way that we were thinking about them 20 or 30 years ago. And I would say this is, we need to take into, when we try to give answers to these questions, we need to think that the world today is not the same as 30 years ago. Not only because you have new actors, new countries, new investors that did not exist 30 years ago, new investment flows from countries that many countries were not used to in the past, because you have more openness and the economy has evolved. But I would say this also comes from the fact that you have new markets, new products, new activities that were not open to foreign investment 30 years ago. Let me give you an example. If we go 30 years back in time, the energy sector was a state monopoly in most countries around the world. Today, energy has been, either supply of energy or production of energy or some types of energy has been liberalized and privatized in many countries, in the sense that private economic activity is possible. And that means that foreign investors are also possible to engage in that new market. So when we are talking about new markets, we need to think that the discussion on what is a security risk is different today than 30 years ago, because you have new areas and new sectors of the economy where foreign investment was not even, where investment in general, not only foreign, was not even an option 20 to 30 years ago. A second point is the development of technology. And technology creates not only new markets, new products, but also technology is a facilitator for investment or creates additional risks for investments in sectors that were already open. And with that, I think we're always thinking about telecommunications, the role of the digital market as it has evolved and developed in the last 20 years, and the opportunities that it has created, but also the risks that have arisen. Last, we could go back into the idea of what is a security risk today. I think who poses a risk and in which sectors, it is a discussion that I'll go a little bit further back in time. If I go 40 years back in time, in the 1980s, many countries in what was traditionally conceived as the West and the East would have a very different idea of what qualified as a security risk back then from the way that one perceives as a security risk today. So when we think about investment screening, we need to think that we need to answer these questions in an environment that has evolved rapidly in the past 30 years. How do we do investment screening? If we talk about investment screening, what are the rules that we are discussing? The first point to say is that investment screening is part of the domestic law of each and every country. So unlike investment protection, where you have international law rules in investment treaties, unlike investment liberalization, where you may have more and more international law rules on admission of investment, on investment screening remains, to a large extent, part of domestic law. And that's for a valid reason, because security and the concept of security is inherent in the concept of sovereignty. What do you have is basically, when you talk about investment screening regulation, you're discussing about the substantive rules on FDI authorization, or foreign direct investment authorization, and the procedural, how one can ask for authorization and when can they get it, when not, what is the process, and what are the legal effects if they get it or if they don't. And this is what we'll try to see, especially when we talk about the French model. The last point to make on investment screening is that, given that it is part of domestic law, we need to think that there are different systems across the world. But what we see, and given how important it has become, is that we see not necessarily a shift towards the same direction, but what we see is that all major countries in the world and more countries adopting an investment screening framework, either adopting when they didn't have one, or codifying domestic laws and updating them. I think suffice to say that on top of the European Union that has adopted the framework only 2 years ago, and many EU member states that have updated or adopted the new framework in the past 2 years. In the past 3 years, we had a complete revamp of the US model. There was a new act in 2018 that completely changed the way of investment screening in the United States. China, I think, is a major player that they adopted their new investment screening framework only last year, which tried to codify, simplify the rules on investment authorization in China. And I think this has been considered a revolutionary step concerning foreign investment flows in China. But also countries such as Australia, Japan, one can witness that many countries have either adopted the new framework when such didn't exist, or they have updated their system and modernized their system. And looking into France, I think I will make some comments on what I view as different from key systems. My disclaimer, my knowledge is limited to EU, French, the German system, a little bit some other EU systems, but outside the EU, I've read a little bit more on the Chinese and the US system. But again, I think your views and especially your knowledge and expertise on the Chinese system would be more than welcome to discuss later on and to discuss the differences. So let's go a step back and start from the point of view of investment screening as part of admission of investment. And as I said, admission is an area that is a domain reserved for home states. And it is up to home states to decide who they want to allow in and whom they don't. Investment treaties, I think here is to make a basic referral. They basically, the traditional investment treaties, or the vast majority of investment treaties, they provide rules only concerning investments made in accordance with local laws. So what qualifies as an investment under international law would be only what we call a legal investment. And the rules that they have would only be about protection of investment only after its establishment. There is very little in a traditional investment treaty on admission. However, what you have in a growing number of investment treaties is that you have more and more investment treaties, including rules on investment admission and liberalization. I think a good example to think here would be the recently announced, not yet concluded EU-China investment agreement, where the focus and the emphasis is only on liberalization, on investment admission and liberalization, opening up sectors of the economy and identifying the limitations concerning market access and national treatment. We'll go into that in a minute because investment screening is linked to liberalization. Before we go there, let me make two key observations. One is that the reason why modern investment treaties focus more on admission than on protection is a result of an increased understanding by states that admission is much more important and as an investment determinant than protection. If there is a French investor who wants to invest abroad and may consider to go to country A or B, the existence of investment liberalization in an investment treaty would maybe much more important than the existence of a strong protection framework. Because investment protection only acts ex post facto if things go wrong, and how you can resolve things if things go wrong. It's a security, it's a guarantee, an insurance policy in the way if things go wrong. But it does not allow somebody to go enter a market and make profits. And this is why more and more investors think that what is more important is the ability to enter a market, especially markets that have been closed so far and markets that have been protected. Closed or protected in the sense that either it was a state monopoly or foreign investors were not allowed in, or there were many restrictions. And what we witness is that the EU is one of the key global actors who promote investment liberalization. The EU has a long history of being a proponent of liberalization in the field of trade. This is what the common commercial policy was about. And it continues with that tradition in the field of investment. The emphasis on the number of new investment agreements, again, is on investment admission and liberalization rather than on protection. We have such rules in EU agreements that don't talk about investment protection, but the investment admission part is very important. And this would be the agreement with China, Japan, Korea, just to mention some of the latest examples coming from the Eastern Asia region. And the point is, why would liberalization in an investment treaty matter more than liberalization that is done in domestic law? And the key argument is that this, by having binding commitments in international law, this creates more openness, legal certainty, and investor confidence, because states cannot take a step back, cannot decide. If liberalization is done only on the basis of domestic law, host states may decide whenever they want to change their national laws and take a step back and not allow more investors in. Having commitments in international law, first of all, and having international negotiations is a way for countries to remove prohibitions and to be more open, and B, make sure that this openness and this liberalization is embedded in an instrument that can change in a very difficult way, that this openness is there to remain. This, I think, in a way explains also the need for more investment screening. With more investment admission and more liberalization, with more sectors of the economy being open on the basis of binding commitments of international law, the more there is a need to assess if in all these sectors, different types of investors pose risks, security risks. And I think here we need to distinguish the objective behind admission and liberalization, that is, and security. With one, we are discussing about a country being open to global competition. So not protecting a domestic industry in a certain sector, and protecting the privatization of different sectors of the economy where private economic activity is considered welcome in certain sectors of the economy. It would help the economy grow and these sectors bloom. But at the same time, by removing these barriers and making investment open, this, of course, can raise risks, security risks, which beforehand did not exist because the sector was not even open. So the more you open a sector and the more there is liberalization, the more security risks may arise, and therefore there is a greater need for investment screening. How does liberalization happen? And I don't want to go into a discussion on liberalization because I want to focus on screening, simply to say that when we talk about liberalization, we talk about market access. So removing a classic or national treatment that you treat foreign investors the same way as domestic investors, MFN treatment that you treat investors from any country in the same manner. Let me say a few things on the market access commitment, which basically is a provision that does not allow a country to impose limitations on foreign investment in sectors in terms, for example, of equity ownership caps. A classic market access commitment that you have in EU agreements is a rule that says in a specific sector of the economy, you cannot impose any foreign ownership caps. Foreign investors could have 100% of the shares or a majority. These are the rules that are prohibited under market access commitments. And this is important. Why, as I say, if agreements include market access commitments and foreign ownership and control of domestic key economic activities is possible, this is why there is a greater need for investment screening to avoid security risks. One may say that this could be done by the way that liberalization happens. And the liberalization can happen via a positive list approach or a negative list approach. Positive list means only the sectors mentioned are liberalized, everything else is up to domestic law. Negative list is everything is liberalized except for the sectors that are identified in an annex. One may say that this is a way to avoid these security risks by simply not liberalizing. But this is not a true alternative, because as I said, investment screening is there to protect from security risks. So the idea of including a sector, even what one may consider as a sensitive one, in a positive list is the approach that the EU has taken and negotiates with its partners by saying that security risks should be assessed on a case-by-case basis, because the general idea is that opening sectors that even may be sensitive and allowing foreign investors is beneficial for the host country, for the home country, for economic growth. And of course, some sectors should be included in the list and shouldn't be excluded for liberalization simply because they pose security risks, because these security risks should be assessed on a case-by-case basis. And this explains also why limiting liberalization is not as an efficient alternative to investment screening. One may say, okay, if a sector is so crucial, then don't open it up for an investment activity. But the answer is, this would not be economically as efficient and would not serve the purposes that investment openness and liberalization serves. So again, this shows that when you're talking about the greater the degree of liberalization, the greater a need for screening. This goes, again, a consideration that we need to consider, a consideration that we should have at the end of that would be that what are valid grounds for blocking, for refusing a foreign investment? And as I said, when there is more openness and liberalization, this creates different types of concerns for host states. Security, and I've highlighted that, and that's what I want to focus on, because this is considered in all systems, not only in the EU, but also in the US, in China, in Australia, in Japan, as the only valid reason to block a foreign investment. If security is the only reason, that means that other reasons are not valid. Why? Because these reasons are the very lie behind why we have liberalization and openness in the first place. So one cannot screen investment and block foreign investment simply because they would put a competitive pressure on domestic investors. One should not use investment screening in principle. We can discuss if that is the case in practice, but in principle, one should not use investment screening simply because the foreign investor in an open sector would come in and would basically, because they are more efficient, they would result in taking a greater market share than the domestic industry. If that is a concern, there shouldn't be liberalization in the first place. Liberalization is there to ensure a fair competition, a level playing field globally for all types of investors. Other reasons that do not qualify as security is what we would broadly call economic reasons. So in the sense that there shouldn't be the idea that for a host state that an investment should be refused if the arrival of a foreign investor would result in, I don't know, in a closure of a factory and let's say effects that it would have on the domestic labor market. If, for example, the foreign investor comes in a sector and their supplies are from abroad, and the domestic investors supplied their products from the domestic market, and the foreign investor gets a higher market share, that means that the domestic suppliers would be out of a job. This is an economic needs test, which would not usually qualify as a security concern. These are economic reasons, which are, in theory, not security. But this leaves the debate, this brings us back to the debate, so what is national security? And how do we define that? And that I leave for the main part. So with that introduction in general on investment security, I think we need to move on to the EU system on investment security. Putting it in the context of the development of an EU investment policy. I don't want to go because I know that you've had the opportunity to discuss EU investment policy before. So simply to put investment screening in the evolution of EU investment policy. Investment is a new area for the EU getting competence only 12 years ago. And of course, investment screening was not at the top of EU priorities. The EU had, first of all, to guarantee the continuity of the investment regime. So the first thing they did was to ensure that member state investment treaties were not incompatible with EU law and would keep applying. Secondly, they had to figure out what they wanted to do with that investment competence and how far did that go. So resolving the internal EU struggle on how to exercise that new competence and how far that competence went. This goes into the discussions on, for example, on the regulation on investors' financial responsibility under EU treaties, on the debates that were held in the European Parliament between the Commission and member states on what should be the focus of EU investment treaties, on the debates that were held internally within the EU on ensuring that EU investment treaties safeguard EU values and interests and promote EU interests, on striking a balance between, because not all 28 at the time thought that the EU they had the same interest and they had different approaches to investment. And of course, that took quite a few years at the beginning. And it was only when there was an EU compromise that the EU was able to negotiate. And this is how the EU negotiated its first investment agreements. I think the agreements with Singapore and Canada and Vietnam being at the forefront of the development of EU investment treaties. And there may have only been 3 treaties so far, but I think these were the most difficult because the EU had to figure out all these internal issues, what was the scope of that power and what they wanted to do with that. Meanwhile, we need to consider that in the past 3 years, the EU had to discuss also what happens with investment regulation on investment between EU member states. And these are the famous Achmea case, the Comstroy case that came out this September, and many more, which is about the agreement that terminated investment treaties between EU member states, which is a slightly different debate. This is a debate on the EU setting aside the rules of how we, using international law in intra-EU relations, violates key EU constitutional principles, and in particular, the principle of autonomy. But on that, we'll discuss later. And the last point, and it was only then that the EU could finally discuss elements of investment admission, which are about investment screening. Another reason why it came so late, and I think this links to a key question on the chat, is about the scope of EU competence on investment screening. And with that point, there are 2 points to discuss. In the aftermath of Opinion 215, one could argue that any rule concerning foreign direct investment falls within the scope of EU competence. And what is very clearly made by the court in Opinion 215 is that exceptions, rules in investment treaties that concern exceptions to investment protection on grounds of public policy of public security do not fall within the scope of member state competence. There is a big part of Opinion 215 that discusses explicitly the argument made by many member states that, well, what if there is a threat to national security? What if there is a threat, and these are internally member state competences? What the Court of Justice said in Opinion 215 was, investment is not different to trade. We had these concerns in trade. Trade poses threats to national security, and internally in the internal market, this is for member states to do. But we shouldn't confuse the internal and the external competence. What the court said in 215 was clear that investment follows the paradigm of trade, where externally it is up to the EU to set the rules concerning exceptions on trade or on investment coming from third countries. And investment screening is part of investment admission and liberalization, which is part of EU FDI competence. But at the same time, the way that this is exercised internally, this is a question for member states to do. So in terms of setting a framework externally, the EU is the single actor, but internally on how the EU divides that competence is an internal question. This is also one of the reasons why the EU set the FDI regulation at the beginning, asserting its competence with regard to this area of investment admission and liberalization. If we look a little bit what the EU does, and I'm taking here the key objectives as they are formed from 2010 onwards, and what the EU says in the Commission in its main documents as to what they want to achieve. Focus equally on admission and protection. And we see here the focus on admission, how important it becomes, both in terms of liberalization and in terms of investment screening. Offer a comprehensive coverage. So this is also an element where it is important to consider that EU competence covers only for indirect investment. For the rest, for other forms of investment, there is either shared competence or there is member state competence, which means that if one wants to take a comprehensive view, the outcome is that the EU and the member states have to work together, whether internally on investment screening or externally when they negotiate agreements. What we need to focus on, though, is the last 2 points, the key objectives of enhancing EU competitiveness and contributing to the materialization of EU external relations objectives. And these are key also for understanding how the EU investment screening framework works. Let's go a little bit to see what it is, how it tries to do what the EU framework does, and then try to answer if these key objectives of the EU investment policy, how they are reflected in the FDI screening mechanism. So why did the EU need an FDI screening mechanism? I think what an argument mentioned up until 2018 was, well, the idea of security is a national one. Even if the competence belongs to the EU could still allow member states to have their own mechanism to screen foreign investment. Why do we need an EU mechanism? And by why do we need an EU mechanism is also a question of what sort of EU mechanism do we need. The key rationale for having an EU-wide mechanism is because we need to have a clear and EU-wide approach to this balance. I said before that if we need to go and think of the question, what is a risk to a security risk? Who are the investors who pose the risk? In which sectors? What poses a risk? I think this illustrates that these questions should not be addressed on, these are questions that require an EU-wide answer. It would be problematic to allow different answers on these questions in different member states. Even if the case-by-case analysis may be different from Malta to Estonia, the answer is that the criteria, the core of the system should be the same. We need an EU-wide approach on how to draw the balance rather than assessing on a case-by-case basis. This becomes even more important if we think that a key sector where investment screening and security risks arise is what we call critical infrastructure. And this is very important because if we think about it, critical infrastructure is not limited to one member state. We have an EU energy market. So if there is foreign investment in the energy supply market in member state A, that would not only affect the security, that could pose a risk not only for member state A, but potentially for a number of member states. Considering that it's an energy, I think, is an easy example. There are more examples of different areas where what we call critical infrastructure, transport is another example. There are linkages between member states. So one cannot say that an investment in country A will only affect country A and will not affect country B in an EU unified system. Another reason that we need to think is that a key reason for an EU-wide approach would be to say that given the freedom of establishment internally in the EU, one should not have an investment, one should not allow a foreign investor setting up a holding company in country A, in the Netherlands, for example, who then have subsidiaries and branches throughout the EU. This may pose security risks if the parent company is acquired by a foreign investor. Why? Because they may have a system of branches and subsidiaries throughout the European Union. And there is a need for cooperation if France authorizes the investment and Germany doesn't. I think this explains the need for cooperation and for a common approach, a common understanding of what the screening mechanism is about. The last point is on where the EU focuses on is that there is a threat in areas of research and development where the EU is heavily involved. And I will take here space, engineering, and the Galileo program. So if there is a foreign investor coming who wants to invest in a project funded by the European Union, which is at the niche of research and development, such as GPS systems. I think GPS is used for the American system, so I should use the EU word. Apologies for not knowing that. So for geolocation systems, if we want to think about that, the EU has a special interest to have a say if a foreign investor who buys that project wants to poses a risk, which is not member state only, but is EU-wide. So I think this explains that these are examples of why we need a common approach and why we need cooperation within the EU, rather than if we need a unified and a harmonized framework. And these reasons explain why the EU approach is an approach of, I'm not sure where is my slide. Nope, probably I deleted that. Where the EU approach, oh, there it is. The EU approach, which is embedded in Regulation 2019 of 2019-452, is enable member states to devise their own investment screening mechanisms, but offer them guidelines to have a more or less similar framework. So guidelines on how they should do their investment screening, which should be done on a case-by-case basis, on member states assessing their own security risks, but on the basis of common EU-based wide guidelines. And secondly, have an EU-wide framework for cooperation between member states. When there is an investment in countries A and B, and they need to come up with a common decision, or there is an investment in member state A, which affects more than that, more member states or the EU as a whole. So this explains the outcome of the FDI screening regulation. And although it is in principle an area of EU competence, and the EU could have harmonized and taken a central approach, the outcome was that since we're talking about security, it's not about competition, it's not about economic needs. It's about security. And this differs from member state to member state. And it should be done on a case-by-case basis. It should better be done by member states, but on the basis of common principles and with a framework for cooperation. Let's look a little bit who are the investors in the EU before we look into the rules. I think this is to give us a little bit of understanding. The EU in the past 2 years amounts for a gradually smaller percentage of global FDI inflows. I'm excluding here intra-EU. If I include intra-EU, that would go up to 40%. But if I leave out capital movements within the European Union and think all other capital flows, the EU is the recipient of 15% of global FDI movement. Who are they? Who invests in the EU? And we see basically it's North America, the UK nowadays, EFTA, the EU neighbors. They amount for more or less 3/4 of investment in the EU. And the other 1/4 comes from the rest of the world. And in that quarter, 25%, China, and I think it's interesting because there is a lot of debate in the news about the Chinese investment in Europe, only amounts for 3%. Where do these foreign investors invest? Basically in areas that we'll go into sectors in a minute, in manufacturing, which is still a good 25% of flows, FDI flows in the EU, retail, but we see also some sectors that I'll say later why they're important, like ICT, telecoms, energy, finance. And I think, but what I want to highlight on the basis of that is that manufacturing and retail are still a good 40% of those FDI inflows into the European Union. So what does the regulation do? First, as I said, enables member states to set their own screening mechanisms. And what we see is that out of 27 member states, we have 18 member states that have investment screening, 6 that are in the process of adopting one, and another 3 that do not. What's interesting here is that since 2017, when the regulation was starting being debated in the EU institutions, there have been 7 more member states that have adopted the screening mechanism, and there have been 5 of the remaining 11 that have adapted and changed their framework, which I find fascinating, how the EU has influenced member states to go ahead and introduce investment screening or amend investment screening, not only to make it compatible with EU law, but also to modernize it. And I think an example of that would be France. What does the regulation say? As I said, they offer guidelines to member states on how to devise their screening mechanism. What they do is they set a list of factors that member states should consider on what is a threat to security, as we said. And when you think about who is a threat to security, the list that you have in the EU regulation is non-binding and non-exhaustive. That means member states could have a different list, including different sectors of the economy, or excluding some of the ones that the EU has. What are the sectors that the EU considers crucial? What we call critical infrastructure. That would be, for example, transport, energy, technologies, critical technologies and inputs. I think telecoms, data processing here would be very important. Access to sensitive information, including personal data. And I think here, when we talk about data protection and privacy is very, very important. And freedom and pluralism of the media. The need that for a democratic society to exist, one should not allow foreign investors to, there should be a check of them investing in either print or digital media, and ensuring that foreign investment activity would not result in any monopoly, in any monopolistic powers in the media sector. Another, going beyond sectors, what the EU says is that member states, they should check also the context of FDI. That means who the investor is rather than where they invest. And the EU says, in particular, one should look, if we are talking about the state-owned enterprise, they should be looked if they pose a security risk. If there is control of the investor, either directly or indirectly by a foreign government. And an example here is if there is a private company, a private foreign investor who receives subsidies from their home country, this is something that should be taken into account under screening. And the last point is, even if they're not directly or indirectly controlled, if they pursue projects or programs that are based in their home country. This is not to say that all of them would be prohibited if any of these investors cannot invest in the EU and their investments would be prohibited or refused authorization, or that they would get commitments. This is just a factor for consideration if they pose a risk. All of these, what we're discussing, are factors, which means, as I said before, economic reasons, protectionism, competitive pressure are not a valid ground for screening. And I think it's clear that to protect the domestic industry does not feature in any of these. Secondly, a key cornerstone of the regulation is non-discrimination of foreign investors. One has to consider if it is a state-owned enterprise or if it is controlled by a foreign investor, but there is no point to say that foreign investors from country A pose a greater risk than foreign investors from country B. A UK investor poses greater risk because they are a UK investor than a Swiss investor, to put it like that. And I use non-controversial examples because one may engage in, the more one looks into the origin of the investor, the more controversial that can be. The next point would be to say that on the system, which is the EU makes a clear reference that one should look into, member states should try to authorize as much investment as they can. If they pose a risk, they should ask, that should be a conditional authorization. They should ask commitments from the investor. And refusing to authorize should only be a last resort, only when commitments are not adequate to address the risk identified. This creates a test on how you may apply security. So it's not so much what is security, but which could be very broad for member states, but this is how you do the assessment. And I think this is something that I want to stress, that the EU is bringing new to the table, that many new systems around the world outside the EU do not follow this approach. It is, many systems give a lot more discretion to national authorities to say, if there is a risk, what you can do. The EU gives a clear approach by saying, you should authorize on the basis of commitments. You first need to identify a risk. If you identify a risk, pose commitments, and not only if the commitments are not adequate, and maybe I introduce here the word proportionate. I'm introducing it here, I'll discuss it in the context of France. Only then you can refuse authorization. So the threshold, there is an idea that one facilitates investment and openness, and screening is not there as an obstacle, but rather as a way to address real security risks. Discretion lies only in identifying what is a risk, not how to address the risk. There one needs to follow a certain process. And I think this is a huge difference between the EU and other countries that have screening mechanisms. Let me go into what are the guidelines. Key part of the guidelines is how should member states do that screening. So it's about process and procedure rather than substance, because substance, as we said, there is more discretion. There is, they talk about the need to have time frames for national authorities to decide. They talk about the need to have a transparent mechanism, a non-discriminatory mechanism. They need to protect confidentiality. If an investor wants to invest and to do an M&A, one needs to ensure that business information and business secrets are not leaked and revealed, because that could be very damaging for the acquiring company and the target company. And the one that I want to focus on, which is, I think, another key innovation of the EU, is the possibility for judicial review. This is a key contrast, let's say, from the point of view of the American system, where in America, there is very little room for judicial review of these judgments. The EU emphasizes that when member states set up their frameworks, they need to offer the investor the opportunity to challenge any decision taken, either if they impose commitments on them or if they refuse investments. This is linked to transparency. This is linked to the point on the process that you need to have a type of proportionality and the preference for commitments before going to refusal. These are ways of restricting the discretion that EU authorities have, offering more transparency and legal certainty to foreign investors, and at the same time allowing member states to do a case-by-case analysis of what is a risk to national security. So the factors are indicative, the sectors are indicative, the risks are not clearly identified. We only know that it could be a security risk, but the process through which this risk is identified, assessed, and in the end addressed is subject to a procedure that is strict, a procedure that is based on a form of proportionality, a procedure that is subject to judicial review. And I think this is a key element of the EU mechanism on investment screening. There are some points in the comments which we need to discuss. I think it will go a little bit later on in the discussion, because I wanted to go into the next point on the next element of the EU screening mechanism, which is on the cooperation. As we said, the first part is the guidelines, and the second part is the cooperation. Let me address a few of the comments. One comment is, why is it in a regulation and not in a directive? I think the EU has freedom to decide how they want to do it. And being a regulation, the key reason why it is a regulation is because it establishes an EU framework. It couldn't have been a directive because there is a framework for EU cooperation. So to have this framework for cooperation, it should have been an instrument that is directly applicable in the member states. This is why it is a regulation. The second point on, I think, on what is political and security, this is a huge discussion, and I think that's what we should focus on in the discussion at the end, I think. And we'll talk about breach of commitments and the implications. Let me say that this is a question for member states to address in their national law. What happens if there is a breach of these commitments? So what is the EU cooperation framework? Let me start by identifying what is the scope of application of this cooperation mechanism. What are the investments where member states, basically it's a framework where if there is a screening, a member state has to notify the EU and the other member states. About which investments? Only foreign direct investments, not portfolio investments. How do you define FDI? On the basis that the EU has done and the Court of Justice in internal law, in internal market law, where you need a lasting link, in the whole state. It excludes transactions concerning corporate restructuring. So if you change the legal person, then this is not an investment that is subject to the cooperation mechanism. What investments? Any investment that is screened in a member state that has a screening mechanism while it is being screened, and for member states or for investments in either for member states that do not have a screening mechanism or for member states that have a screening mechanism and an investment is not screened, up to 15 months after the investment is done. So this means that if there are 15 months, once an investment is completed, an M&A transaction done, then there is no way that it could be refused afterwards, authorization. For the first 15 months, either it is screened and goes through the authorization process and the EU mechanism, or if it is not screened, it could be subject to cooperation, and there could be a request for more information for the first 15 months. The next point would be discussing about who is an investor. The mechanism applies to non-EU investors, either direct or indirect. So it is about informing other member states only if there is a non-EU investor, either directly or indirectly. We'll talk about that concept when we look into the French system. What is important, though, to say is that member states may also screen EU investors. France is a good example. They screen foreign investment is any investment coming from anyone who is not French. So a German investor in France would go through investment screening. That screening does not have to be notified to Germany and to the Commission. So member states may screen EU investors as well, but that screening should not be notified to the EU. And second, and most importantly, we'll look at the French framework. When they apply security for a German investor compared to a Canadian investor or a Chinese investor, for the German investor, the concept of security is the one identified in EU law. Very, very narrow. That's not the case for non-EU. So the concept of security when a member state screens EU investors is the very narrow concept that you have in EU law, which is to be contradicted to the broader concept that you have for non-EU investors. Last point is you can also screen EU investors. EU investors who do not have business activities in the EU are foreign investors. So if you have a Canadian company setting up a letterbox company in Cyprus or in Malta, where it's very easy to, this would be a Cypriot investor, and then that Cypriot company invests in Spain. That would be an EU investor in Spain, a Cypriot company. But if it doesn't have any business activities in Cyprus, although it is a Cypriot investment, if it is controlled by Canadians, British, that would be a non-EU investor. And that would be subject to the scrutiny and of the screening mechanism. Okay? So what do you do with these investments? The regulation sets two basic rules. One for member states, with screening mechanisms, and one for member states without a screening mechanism. The first member states, the ones that have a screening mechanism, the member state that has the mechanism has to notify the Commission and other member states. Not only they may notify, they may also ask for their comments and their views of the Commission. So they may proactively search for their comments. The Commission and other member states, they can ask for information, the notifying member state. They could say, the Commission usually says, for example, okay, how about that investor? Who owns it? What are the products? What is the market that they are engaging in? Do they have any, do they do any R&D activities? Who are the customers of their products? These are the type of information that the Commission can ask the notifying country and the investor. Once they receive that information, there is a tight time frame, and the Commission can submit its opinion, and the member state can submit its comments. Other member states submit comments. To whom they submit that? To the notifying member state. Who decides in the end? The notifying member state. So it is a decision that lies exclusively with the notifying member state. If France wants to authorize an investment, does following French law and the procedure in France, and they receive an opinion by the Commission saying you should have this commitment, and an opinion by Germany saying you should refuse, the decision lies with France. What the Commission and Germany think would not affect the outcome. The only obligation that France would have in that example would be to give due consideration to the comments made by the Commission and Germany. What is that due consideration? There is a big debate here on what that means in the context of the duty of sincere cooperation between the EU and its member states. I would say that in practice, it doesn't lead to much. If France wants to authorize an investment when the Commission and all 26 other member states don't, They could simply say, we could consider this, and for this and that reason, we disagree, and they take the judgment. So many say that this is a flaw of the system, because even if you notify, the notifying member state takes the decision, and they only have to give due consideration to what the Commission and other member states think. Others think that this is actually a big advantage of the system, because it should be the notifying member state taking the decision on the basis of their national interest. And if another member state doesn't want to, well, if there is an investment in their territory, that's when they can act. Germany cannot discuss what is a national risk from an investment by a UK investor in France. This is the logic and the rationale there, and the balance. We could discuss if this is a good idea or not later. What happens with member states that do not have a screening mechanism? Obviously, there is no need for notification. What happens there would be if the Commission or another member state is interested and think that there is a risk, then they ask the member state where the investment is made for information. That member state has to provide information about that investor and ask the investor to offer that information. The Commission and other member states will submit comments and opinion, but again, the decision lies with the member state where the investment is made. To give you an example, the country that I originally come from, in Greece, until now, they're thinking of introducing an investment screening, but they don't have. When there were different projects acquired by non-EU investors very recently, not so much even in the past year, there was a discussion. There was no investment screening in Greece, so it didn't go through, but there was the opportunity for other member states to ask information from Greece and from the investor about the investment, and they would give their opinion back to Greece, but it would be Greece that would take the decision. And without a formal mechanism, they couldn't refuse in reality. What I said again is important is to consider that there is confidentiality. Given that you have an EU framework for cooperation and many member states are involved, you can understand that a leak can happen very easily in the EU, and this is why there is an additional obligation on everyone involved to protect the business interests of the investors. So what do we have out of this cooperation mechanism in its first year of application? The Commission tells us that there were about 1,800 transactions that were notified to the Commission, although they basically come from 7 member states. So we see that although we have 18, only a few of them are used to the mechanism. And it makes sense because they are the biggest member states who have a tradition and understanding. Some newer member states that have just introduced an investment screening have not been able to use it so far. Out of these, only 20% of these transactions were formally screened in member states and by the Commission. And of them, 79 were approved without conditions, 12% approved with conditions, and only 2% of that 20% of those 1,800 were prohibited. So we see that the threat, the system appears maybe too much, and it would end up with very, very few cases of an investment being refused. There is, however, a number, and I expect that to grow, where you have approval with conditions. So what are the key outcomes more broadly? I think it creates transparency, and that's helpful for foreign investors in Europe to know that there is a mechanism, a system with tight timeframes all over the EU, a system where there would be cooperation, a system where they would have the access to judicial review if they don't like the decision taken by a member state. This is important for the EU and the member states because they have now a better overview of the threat that foreign investment coming from some countries or some investors in some sectors actually creates. It's an opportunity to review and reconsider what is a security important for the security for each member state and for the EU as a whole. It helps the EU reshape and redefine and understand what they call their strategic interests. And I think, although there is discretion on what is security, I think this the application would help crystallize what we actually mean by security. And this mechanism has been a valuable experience for member states that did not consider investment screening. And that was the majority. And now it would be a slim minority. There would only be 3 member states as of 2023, probably, without a screening mechanism. I think Cyprus, Bulgaria, and another one. So I can't remember the third one, apologies. So that would mean, and these countries can learn from EU cooperation. However, at the same time, one may say, is it effective cooperation? Depends on what member states do with it. They have the opportunity to set up if they want and to devise a mechanism as they seem fit. So depending on how cooperative member states are, if they take the Commission into account, as I said before, opinions or comments by other member states or not. So it is a soft mechanism for cooperation rather than a hard mechanism. And it depends on how willing member states are to truly cooperate and take a common approach. A second part that the EU notices is that there are many organizational hiccups that affect the efficiency of the system. Many member states, especially new ones, now mean this mechanism requires more resources. You need more people in the Ministry of Finance or in a special organization to deal with investment screening and apply these procedures. And many countries don't have that. And I think, and also on how you do the exchange of information and how you notify in the outcomes, which makes sense whenever there is a new EU system. I think these organizational hiccups is something that usually the Commission is very good at tackling, and it makes sense that they exist at the beginning of a new system. So I think this is only the teething problems of the mechanism. I think they can be resolved. The first one, if member states are willing to cooperate on a soft law, on a soft basis, this, I have some reservations. And because I'm going beyond my time, I want to go into France and look a little bit the law and what France has done after this framework. France had an investment screening since the 1960s. They changed the law in the 90s, and the more recent one was in 2019. There have been some additional changes in 2020 during the pandemic, where they have been even more restrictive. And I'll go to discuss that in detail and to see how the pandemic has been an opportunity or for member states to tighten the rules on investment screening. So where would you find the rules? I put them on the slides if you want to have a closer look, but I think you can all Google them. Basically, they're the rules found in the Code Monétaire and Financière. And what do they say? Who is subject to screening in France? Foreign individuals, foreign companies, for French nationals who are non-tax residents in France, French companies that are controlled by non-French nationals. So basically, as we see, they extended to EU investors as well, A, and B, the fact that a company is established in France doesn't mean that it would be excluded from investment screening. If they are controlled by non-French nationals, they would be subject to screening. What are the transactions that are subject to screening? Basically, it would be what we call a share deal, an asset deal, or a transaction resulting in a threshold crossing. What is a share deal? If you get a controlling stake in a French company. How do you do that? That's based on the rules of the French Code de Commerce that says either you need the majority of voting rights or you need to have de facto control to be able to appoint the majority of the management or the supervisory board in a French company. So a share deal, which is the most important one, is when you obtain, a foreign entity obtains a controlling stake in a French entity. And controlling a stake would be hold majority of voting rights or de facto control. The second would be what they call an asset deal, when a foreign entity acquires part of a branch of an activity of a French company. And the third one, which is only for non-EU investors. So for EU investors, you only check share deals and asset deals. For non-EU investors, you would also check any acquisition of more than 25% of voting rights in a French company. And it's interesting that during the pandemic, that went down to 10%. It used to be 33%, then it went down to 25%, and during the pandemic, supposedly only for a temporary period, down to 10%. Okay, so if a Chinese investor buys directly or indirectly 10% of a company in France, they will be subject to investment screening. Exempted transactions, basically an intra-group transaction, or if you do a share deal after you've done an authorized threshold crossing. So if you have, if a Chinese investor buys 25% in a French company, they go through investment screening, they're cleared, and then they extend their rights to 50%, they would not need to go again through investment authorization. Okay? In which sectors? And then look how the French go a little bit beyond the sectors that are identified in the EU regulation. Telecoms and data processing. Any activity relating to means of telecommunication detection and interception. Activities relating to private data system security and data capturing. Cryptology, so on delivering messages in an encrypted way. Issues concerning national defense and security. Any activity that is carried out, and this is very broad, by a company that holds in custody French national defense secrets. The second is, I think, even broader, an activity carried out by a company that has a study or supply contract with the French Ministry of Defense. Of course, I think the third one makes sense. If you produce or sell weapons or ammunition, or if you engage in an activity that has to do with the use of chemicals that can be used for a terrorist activity. I think, again, these two are the ones that I think it would qualify as security related in any context. And private security, offering private security services in France can only be done, has to be subject to screening. Then we go to what they consider critical industries. And they say critical or remember in the EU was critical infrastructure. In France, that's energy, water, transport, telecommunications, is facilities deemed vital within the French Code de la Défense. So these would basically be certain areas, land acquisition in certain areas where the French minister has considered vital for French defense. Public health. Another big subcategory would be any company that has R&D activities and R&D, research and development, in key sectors such as cybersecurity, energy, biotechnology, AI. So at the top of technological development, if any company, French company, engages in R&D, any investment that would result in majority control, share deal, or a threshold crossing, more than 25% for non-EU investors, would be subject to screening. And then the other sectors, remember freedom of press that you had in the EU, you have written and digital press in France. That's a new addition. The French didn't have that sector before the EU screening. They added it very recently. Gambling, and another one that the EU has, the EU had and the French got, food safety and food security. So sectors concerning production, process, and distribution of agricultural products. What is the process, the procedure in France? The investor notifies the French Minister of the Economy. And then there are two stages. The French have the minister has 30 days to answer the investor. There is a list of documents that the investor has to provide. There is an ordre in the French commerce that says you need to tell us about who you are and the assets that you buy and the percentage. And there is a checklist of what they have to offer in that notification. That would be assessed by the Ministry of Economy. And within 30 days, they would say, this is you don't need prior authorization really because you don't fall under our criteria. They would grant the authorization without conditions. They would outrightly refuse, that never really happens. Or they would say, we need to look more into the case. If they look more into the case, then you go into a stage 2 examination. There are another 45 days, and the outcome would be either to refuse authorization, grant authorization with conditions or grant authorization without conditions. So you have a stage 1 and a stage 2. Stage 1 basically saying you don't need authorization, or you get it without conditions, or we need more time. And when they do more time, they could refuse, grant authorization with conditions or without conditions. If the French minister doesn't reply, that means that no authorization is given. Because that means that usually it can take a little bit longer. So it's not a deadline that is very strict on the French administration. What commitments could one ask from a foreign investor in France? For example, they could say that you could keep the Code Financier provides some examples. They say, for example, you could ask the foreign investor to keep offering the same activities that the target company did. If you supply water that you need to supply, and you cannot simply change your distribution network. To security, concerning the security of its supply or products or services. If you're an energy distributor, that you need to secure that you supply your supply of energy, where you get that energy from energy producers. If you do R&D in France, that you're going to keep your R&D in France, and you're not going to simply shut that department down and move it to Switzerland or the US or the UK or China or wherever. That any sensitive activities that are carried out, one would look into that if you do a subcontract concerning a defense, for example, that this would be carried out by a French company, that you didn't do any subcontracting to non-EU companies, that you give access to information to French authorities. So the ministry would say, we would need to be updated by you every 3 months about X, Y, and Z and your activities. And last, about corporate governance, so that they need to have a corporate governance mechanism, basically in a way to ensure that they don't go bankrupt and that they keep offering their activities. What is important is that in the French system, you have a key requirement of proportionality in the assessment of, is there a risk? What are the commitments? What is the risk? What are the commitments? Are the commitments suitable and necessary to address the risk? If not, then there is an authorization without commitments. So although there is discretion in identifying the risk, the French follow or exemplify the EU model where the process is very tight. There needs to be a consideration of commitments, or the answer that they give to an investor has to be proportionate. And they should prioritize commitments, and the commitments that are suitable and necessary to address the risk that is identified. So there is discretion with the French Minister of the Economy, but that discretion is subject to a proportionality exercise. Next point in France, when can you refuse? Basically only when commitments are not enough, or if the investor has committed a serious crime, and there is a list of what is a serious crime in the past, or if they were given an authorization in the past and they breached the rules of that prior authorization. What happens if an investment goes ahead without authorization, or if there is a violation of the commitments? There are sanctions, and I'm not an expert in French administrative law, but the way I understand is that the sanctions can be from very soft. So you haven't notified us about the commitment, please send us a notification, all the way to saying, okay, you went ahead without authorization, we ask for these conditions. Or they could impose penalties, financial penalties. So they could be paying thousands of euros per day in a penalty. And in the end, they could just say, simply, this is not authorized, we unwind the investment. You have to sell the shares that you bought. Okay. So to conclude, I think I want to ask to think in 3 ways, and I'm sorry for taking more time than I thought. Is investment screening necessary and welcome towards investment openness? And my answer would be, it's necessary because the more openness you have, the more risk you have. And I would say it's welcome because if the alternative to investment screening would actually be no liberalization and no liberalization of investment. I think investment screening a lesser evil than protectionism and simply shutting foreign investment out. And I think it's welcome because it increases transparency, not only in the EU. In every country that has an investment screening, transparency is a big gain, and it's a big gain for everyone, rather than having a system that does not have that. How about the EU approach? I also think it is a necessary and welcome step. Necessary because the EU is very open and has traditionally been very open, and welcome because it helps member states that don't have the experience to get there, and also to increase transparency within the EU as well for non-EU investors. And I think this is a very well, and there are many who say the system cannot work, it depends on how member states cooperate. In the first year, it seems that member states are cooperating very well and they understand what it is about. And I would say it is a welcome step because it shows that it is not a big threat, and member states seem to be using it, at least in theory and in principle, in a way that is actually addressing security risks. The last comment on the French, I would say that this is a welcome step towards the modernization, how national systems should be like. Why? Because I think they do a very fine balance between keeping discretion to identify what is a security risk and offering more transparency and certainty to investors on the mechanism and the opportunity for judicial review, and that the test is actually one of proportionality. And I think this is a model that I think is a way to ensure that investment screening is used to address security concerns rather than protectionism, in a way that is transparent, in a way that would not be viewed as a threat by foreign investors or by other countries. It would not create what we've witnessed in the relations between China and the UK or the US in the past 2 years concerning their investment in telecoms. And I think it would help depoliticize disputes. And contrary, my last point would be that although many would argue that investment screening is coming from the West and as a new mechanism, as a new wave of protectionism, I would say that the West or all the world is more open today than it has ever been to foreign investment. So this is a step back in the sense of not being as open as one may have wished, but it, in my view, presents a guarantee of openness and an ability to keep opening and liberalizing our market, globally markets to foreign investors, while at the same time respecting the sensitivities, the political sensitivities of different actors. With that, I'll stop. Thank you for bearing with me for so long, and happy to start the discussion.
Thank you so much for this very, very interesting topic of EU regulation on foreign investment. Especially, you provide many information about the screening mechanism, the concept of security, and also the member states' legislation. And I think most important, your conclusion is the investment mechanism is not, is not a tool or instrument serving for protectionist purpose, but for truly security consideration. I think this conclusion might be not totally acceptable by the audience. I think there are always some skepticism concerning the use of the application or the interpretation of security and the use of the concrete use of this mechanism. For me, I believe that the existence of this screening mechanism will increase the cost for foreign investors. The cost not for the economic reason, but also for many other considerations. One, for example, a Chinese state-owned enterprise intends to invest in Europe. This state-owned enterprise has to reflect and prepare the kind of due diligence how to go through this EU screen mechanism. So I think the very existence of this mechanism will increase the cost for foreign investors towards EU. So this is one of my reflection over the value of this mechanism. The second issue is the very existence of the mechanism. If we consider the portion of the investment flow between EU and the non-EU countries, as you have already described, the majority of the inflow of foreign investments come from US. And this political relationship between EU and the US could be a very important factor to the outcome of just you have described. The majority of this application has been approved. Only a very small portion of the application is refused. But turning to the Chinese perspective, I don't know whether this outcome would be similar between the EU, US, EU, and China. So I suppose probably for Chinese investor, maybe the first step is to invest in US, and then second step from US to EU could be more easy for the Chinese investor. This is another joke. Probably for the Chinese investor to US may be more difficult. So this is my very brief comments. I'd like to open the floor to audience. They may have more interesting questions. So anyone who wants to ask a question or bring some comments, could raise your hand, or you could also type your question in the chat room. Any question will be welcome. So I open the floor to Angelos and to all the audience. Thank you. So probably, Angela, you can...
Let me give you some time to the rest to think of their questions and type in the chat and try to answer what you said. I think on the first point on... I was muted, sorry. Let me give the floor to let me allow people to think a little bit more before if they want to ask questions, and go back to the questions you asked. On security and protectionism, I think the concept is very broad and there is discretion. And I agree that it could be misused. So what I think it has the potential to be used to address security. But it also has the potential to be used for protectionism. And I think this is a real threat. It can be used to, and I think though what you have in the EU system, where you have a tighter process, would reduce the risk of being used for protectionism. Not that the protectionism would not exist, but rather than that it would be a smaller risk. The cost for the investor, I agree. If there is a Chinese investor who wants to go into Europe, this screening mechanism raises an additional cost. But we need to think, what is the alternative? The alternative would be not to allow that Chinese investor at all to enter the European market. And it's not only in Europe. I think it would be the same in China, that is very open now to EU investors. Without the screening mechanism, the option would be not to invest at all in China, or having to go through on a case-by-case and sector-by-sector and get I think the Chinese system, to my knowledge, before was a labyrinth of, you had to get some approvals at the federal level and some at the province level and from different ministries. And it was a much more complicated than the one that the new Chinese law has introduced, which has discretion, but is a one-stop shop. It's more transparent, it's clearer. So I think the alternative to screening is lack of transparency, greater risk, or in a system that is more transparent, and I'll use here Germany, no access at all. So this additional cost to me is less than the benefit that would come from openness, because screening allows openness. Now, to go to the point where you talk about the Chinese investor where you say, as I mentioned, the majority come from North America or Europe, investors in the EU. So that would be the US, Canada, the UK, Switzerland, EFTA, and I said 2% were not authorized, and 12% were subject to conditions. And we don't have the data where they were from. So as I said, 3% of EU inward investment was from China. Maybe that was the 3% that was all subject to conditions. So the fact that it's that small number doesn't mean that there is really, that these statistics are reflected per country of origin of the investor. So to that, you're absolutely right that you may have a higher percentage of Chinese investors who are refused or subject to authorization, to conditions, than American investors in Europe. That I absolutely agree with. And I think this is a question which, in my view, is subject to judicial review. And I would expect the Chinese investor to rely on the principle of non-discrimination and to take an EU member state to the European Court of Justice, to national courts first, and to the European Court of Justice on the way that they have applied this principle. Of course, I would expect the court to be very, to give deference to what is security and to the assessment. But I think the court would there say that there is a duty to inform, there is a duty to justify. So what we think in principle that the member state has to identify the risk, make an assessment, see what commitments would be suitable and appropriate, and if there are, only then refuse. I think this process would be scrutinized by the court without discussing what is the risk and leaving that to the deference. They would go into the process. And if they saw that an American investor got out of something that a Chinese didn't in the same sector, then I would expect the court to address that. But I think in practice, that's true that there are different political perceptions about companies from different countries in the world, in the EU. And you're right, I think it would be much more difficult for a Chinese investor in the US than in Europe at the moment. And the reason I think is that the US do not even have that, they have even more discretion. The EU system, I think, is the one that has the least discretion. The US offers a lot more discretion on assessing what is a risk to national security, and there is very little scope for judicial review. And as far as I know, the Chinese system is also not, gives a lot of discretion. It is more transparent and it is a clearer guidance and centralized in a one-stop shop. So that is a positive aspect. But still, in terms of discretion, I think the Chinese followed the American approach, which gives a lot of discretion. So I think in that sense, the European model is the one that creates the least cost for an investor without supporting. And I think also what the Australians are the ones who are closer to the European model from what I read. I think I'll stop it there to pass the floor back to you or to the audience.
Thank you so much. And now I will open the floor to anyone from the audience. If you have any question, don't hesitate to ask and to take this opportunity to have a discussion with Angelo. Okay, so if there is no, let me have a look. If there is no question, then I will thank you again, and I hope we can keep in contact on this subject. I think most of us, among members, among the audience, will have interest to make study or inquiry on the foreign investment regulation, not only related to the screen mechanism, but larger, wider perspective of EU regulation of foreign investment. So I hope we can keep in contact to share information and to have your expertise in guiding our research in this field. So thank you so much again for having accepted our invitation. And I hope we can meet you physically sometime next year. I hope with the amelioration of the health situation, the global health situation, we can meet face to face. So thank you again, and I wish you a very pleasant and a happy end of 2021, and I wish you a very happy 2022. Sorry. Thank you so much.
Thank you so much again for the invitation, for the discussion, and my wish is again to be able to do that in person, hopefully sometime in the future, and best wishes for the new year. Thank you again.
Thank you. See you. Bye-bye.
Goodbye.